You're ready with your argument. I'm going to ask you to unmute your microphone so you can proceed. And Mr. Asfar, Mr. Wallace, excellent. You just muted yours. Just a reminder, Mr. Wallace, you have 5 minutes for rebuttal, sir. So if you'd like to take up to 5 minutes, let me know. I've got a courtroom clock here, and we're ready to proceed with your argument.
Good morning.
Good morning, sir.
David Wallace of Bentley and Bruning in Sarasota on behalf of the appellant James Money. He was plaintiff below. With me at our conference table at a safe social distance over here is Albert Sanchez, who was trial counsel and also co-counsel with me on the appeal. I'd like to reserve 4 minutes, Your Honor, for rebuttal. Thank you.
Very good, sir. You may proceed.
Mr. Money was the plaintiff below. He was a consumer seeking a variety of remedies under a variety of statutes, but the one we're here about today is FDUPTA. One of his claims was under FDUPTA. And this case is about the attorney's fees claim under FDUPTA following Home Performance's acceptance of a proposal under the offer of judgment, the statute and the rule. The trial court denied Money's motion for summary judgment, Money's motion for attorney's fees as a matter of law, concluding that the Mady case, which was cited to the trial court by Mr. Sanchez, that the Mady case by the Supreme Court of Florida was inapplicable. And Mady is an interesting case. It's decided in 2011. Mady was decided in the context of a Magnuson-Moss Warranty Act case, and also a very similar fact pattern with regard to the settlement in that case. In other words, there was a proposal for settlement that was accepted. There was a reference in the proposal that attorney's fees were not included. And then the plaintiff, the consumer plaintiff under Magnuson-Moss in that case, sought attorney's fees. And the question in Mady, which was at the Supreme Court of Florida on conflict jurisdiction, one of the conflict cases being the Dufresne case from this court, the question in Mady became whether the context of the settlement serves as a, in my words, substitute for the actual judgment in the attorney's fees analysis.
Mr. Wallace, let me ask you something. In the offer of judgment statute and rule, the default appears to be, I will pay you X, or I will allow a judgment to be taken. And for some reason in this case, through negotiation, I'm assuming, there was no agreement for entry of a judgment. Indeed, the negotiations appear to have led to a situation where someone agreed to voluntarily dismiss the case. Does that make a difference to the extent you want me to look at an MMW case?
It doesn't make a difference because the same thing, as I understand it, happened in Mady. Mady had a voluntary dismissal as well. By the way, the dismissal carved out, just as the proposal carved out attorney's fees, the dismissal carved out attorney's fees. So I don't think it does make a difference. Obviously, if we had a judgment, we wouldn't be having the exact discussion we're having now. So it makes the difference in that respect.
And the reason we wouldn't be having that discussion is because the statute says the fees are contingent upon a judgment. So walk me through analytically how we get from statute says judgment, you get fees, to we settled this by proposal for settlement, we did a voluntary dismissal, we get fees. Walk me through legally how you get there.
Your Honor, yes, and that's exactly that. We walked through the same way the court walked through in Mady.
No. I read Mady. I'm curious your thoughts on how we get there, because Mady uses this wonderful language of something being tantamount to a final judgment. And this isn't the only place we sometimes see that magic word tantamount. Can you, let me put it this, can you elucidate for me a limiting principle on what is or is not tantamount to a final judgment for purposes of applying the Florida Deceptive and Unfair Trade Practices Act's fee shifting provision?
I can certainly try, Your Honor. And
Give it a shot.
And I agree that tantamount to a judgment is one of my favorite phrases from Mady. What happened in Mady, and I'll try to put this as I understand in my words, but what is significant is that the settlement took place in the context of the auspices of the court, is I think the phrase used in Mady, that
Right.
we have
which is true of all lawsuits, right? I mean, everything that happens in a lawsuit is under the auspice of the court.
Everything that happens in a lawsuit is, but not every settlement is. And I think that distinction is made in Mady, is that you could settle a case just through a phone call or an email early on. You can settle a case with or without an offer of judgment. You can settle a case in a variety of ways. And
to go to Judge LaRosa's point, you could settle a case to have a judgment entered, or you could settle a case and have a voluntary dismissal entered.
And that's correct. That's correct. And in Mady, they had, again, the comparison to Mady is in Mady, they had a voluntary dismissal. There's also a judgment mentioned, reference required, if you will, in Magnus and Moss. So they theoretically could have had a judgment agreement in the Mady settlement, but evidently they did not. So what the distinction that I would make from this settlement and other settlements is that some of the phraseology in Mady, the imprimatur of the court necessarily carries judicial implications, judicially sanctioned change, and the settlement remains under the court's full jurisdiction, not because it's a settlement, and not because it's in a lawsuit, but because it's under the statute and the rule governing the offers of judgment. And so it is more than just a settlement.
How do you explain, Mr. Wallace, the appears to be a good number of cases looking at FDUPTA that reject your position and don't agree with the situation that this is be like akin to a confession of judgment in a 627 case or a confession of judgment in an MMW case. So how do you address those cases that reject your position?
I don't see that we have cases that apply the position that we're in, that are applied to the position that we're in. I'm not aware of any case where the progression was what we have, which is a settlement under an offer of judgment, as opposed to, say, a voluntary dismissal case or some sort of other reservation of, some other reservation of jurisdiction case, some other context. And Your Honor, I could address a particular case if you have a particular case that you're referring to, but my understanding is that we do not have a case where the circumstance is exactly what we have here, which is a settlement reached in the same way that the settlement was reached in Mady under the same statute, the same rule. And Judge Lucas, to go back to that phrase, tantamount to a judgment, our contention here is that if a settlement is tantamount to a judgment under a particular set of facts, as it was in Mady, and we have that same set of facts, that our settlement is, as it was in Mady, tantamount to a judgment for the same purposes. And the purposes we're asserting here are that the settlement under the auspices of the court, tantamount to a judgment, takes the place of the judgment in that analysis, in the sense that if it's one of the hurdles that our client had to cross to get to these other factors for determining whether they're entitled to attorney's fees, the trial court said, no, you don't get over that first hurdle. Our position is that gets us over that first hurdle. We should be remanded to the trial court for consideration of the other factors.
But I'm going back to Judge Lucas's earlier point. I'm curious how your position does justice to the statutory text.
Well, I think it does justice to the statutory text every bit as much as it did in Mady. Mady had the word judgment in the Magnuson-Moss Act. Ours has the word judgment. And then the dissent in Mady, made the same argument that I understand Home Performance to be making here, which is they say, well, here's the word judgment, where's your judgment? And the majority in Mady rejected that argument. That is I believe there were two arguments in the dissent. That's the second of the two arguments in the dissent. And it was rejected by the majority in Mady. And instead, the majority in Mady said, by the way, and I'll get to this in a second, using language that is general in nature, not limited to the Magnuson-Moss, but the majority said tantamount to a judgment. And we're not going to say just because the word judgment appears in the statute in the context of the fees analysis, we're not going to hold their feet to the fire on that. So that strict construction argument, Your Honor, was rejected by the majority in Mady.
And there's nothing in the record that suggests why the offer of judgment as accepted dealt with a voluntary dismissal as opposed to entry of a judgment.
I don't recall that there is, Your Honor.
Okay.
Mr. Wallace, help me out, because the actual issue with the case here, we're dealing with a proposal for settlement. Is the language, quote, proposal for settlement, which is what was provided here for the parties, is that, if you compare that to Mady, there was an offer of judgment. So am I reading or am I mincing words too much, or does that make a difference where you're dealing here with a proposal for settlement and the other one deals with an offer of judgment?
Well, far be it from me to tell you that you're mincing words, Your Honor, but I think that is a distinction without a difference.
Okay.
I think it is a proposal under the same statute, and the proposal complies with the statute and the rule, and the proposal expressly excludes attorney's fees in what we contend is clear and unambiguous language. So I do think that is a distinction without a difference here. I mean, I think that if you know, what I come back to is that if this settlement ticks off all the boxes and traces how a settlement was attained in Mady, and if that's, again, I made reference a minute ago that there are some general statements of law in Mady that are not, at least to my reading, limited to Magnuson-Moss. One is the first sentence from the analysis section of the Mady opinion: a settlement produced pursuant to Florida's offer of judgment statute, section 76879, and Florida Rule of Civil Procedure 1.442, is under the auspices of the court in which the dispute is being processed and is tantamount to a consent judgment. And that's one general statement of Florida law, and that's where Florida law stands right now.
How about this, Mr. Wallace, since we're talking about what's tantamount to what? You have a proposal for settlement here that, although it has a carve out for attorney's fees, it does not explicitly say the offeror shall be entitled to attorney's fees. Okay. So as I read that taken as a whole, you all are basically agreeing we're going to carve out attorney's fees. We're going to litigate it later, which is what you're doing now.
I agree.
All right. That being the case, the fact that it was not purposely baked into the proposal for settlement, all right, they did not agree to pay your fees explicitly under the settlement. Basically, they just said, look, we're going to put fees aside and we're going to litigate it later. The fact that they did not agree to that, how can you say that's tantamount to a consent judgment for fees that includes fees?
It's not a consent judgment to an entitlement to fees, Your Honor. It's a consent judgment that we're still, the phrase I think is the fees were excluded, and it references the attorney's fees which plaintiff claims in this matter. So the carve out is that we still have a right to claim them. Not that entitlement is guaranteed, but that we still have a right to claim them. That's the carve out.
But your argument is that this is akin to a consent judgment, and a consent judgment under FDUPA would be mandatory, or almost mandatory. But it would give you the right, unquestionably, to seek fees. You're trying to take it a step further and say, well, they consented to judgment as to a principal amount, therefore it's the same as a consent judgment that would automatically give rise to a legal right to fees under the statute. I don't see the distinction.
Well, we have to go through the remaining analysis. Obviously, under FDUPA, there are a variety of factors that have to be considered that the trial court never reached. What we're saying is that tantamount to a judgment takes the place of the actual judgment.
Right. And that's kind of my point, is that they did not that part, the entitlement to, they did not consent to that. So how can you say this is tantamount to a consent judgment on that issue when they didn't consent to it?
I would disagree that they didn't consent to it, because the Florida law is the general principle that I've just stated here in Mady. That is the controlling Florida law as of right now from 2011 forward.
Yeah.
And if that's set of circumstances brings us to something that is tantamount to a judgment, and that's what they agreed to in the settlement.
But in the Maddie case, relying on the MMW statute, Justice Lewis says something like, if a consumer finally prevails, he or she is entitled to fees. And FDUPTA doesn't have that provision. It doesn't say anything like finally prevails. It says contingent upon a final judgment, fees will be awarded. Isn't that different?
Well, the prevailing party analysis, and I'll make reference now to this court's Dufresne case, which was one of the conflict cases that led to Mady. And what came out of the Dufresne case, also of Magnuson Moss, is that that the party is not precluded from being considered a prevailing party. That's what we're seeking here, that the prevailing party analysis and the whether fees are actually awarded, with things like, can the party that's required to pay actually afford it? What were the circumstances of the case? Was there bad faith? That all we're seeking is to get before the trial court with not being precluded from being the prevailing party in the attorney's fees analysis.
Mr. Wallace, you're about to go into your rebuttal time. If you want to stop right now, you'll have just less than 4 minutes, or you could continue as you see fit.
I'll hold for my rebuttal. Thank you.
Very good. Thank you. All right. Okay, now I'm going to ask you to please mute your mic. Excellent. Mr. Asfar, if you could proceed, sir.
Good morning, Your Honors. Mr. Wallace, Mr. Sanchez, may it please the court. Rick Asfar, Cottney Construction Law, on behalf of the Appellant Home Performance Alliance. Here with me, also equally socially distanced, is trial attorney Mason Picorni. So one of the things that I noticed from starting with the initial brief and then moving on to the reply brief is that what was argued below and what was initially argued in the initial brief was, under Mady, accepting the proposal for settlement means I get FDUPTA fees. Don't pass go, don't collect $200. It wasn't until we pointed out in our answer brief, consistent with our arguments below, that there's really 3 things that you need in order to get fees under FDUPTA. Number 1, you need to have a judgment. Number 2, you have to have a prevailing party determination that the person who's seeking the fees is the prevailing party. And number 3, that it is a case which is appropriate for the court to exercise discretion. And it's important to note that FDUPTA is different than some other statutes. It is a bilateral statute. It is an equal opportunity offender, applies equally to plaintiffs as it does to defendants. Plaintiffs also need to trigger the discretion before you get fees. We spent a lot of time this morning talking about the first part, whether or not there was a judgment, but there is nothing before the trial court regard to the other 2, which was whether or not there was a prevailing party and a discretion, because plaintiff's trial counsel made the tactical decision to set this for a non-evidentiary hearing and not submit any evidence with respect to the factors in Riley and Humane Society, or even say, hey, I'm the prevailing party. Rather, what happened was, before the trial court, plaintiff appellant argued, accepting my proposal for settlement is tantamount to accepting all of the allegations of the complaint, and I win and I get my fees. And now we have kind of receded from that position. I think we all agree that that is simply not the case. So what I'd like to note for the court, and what I will cover, unless there's something in particular y'all would like me to cover, and I'll try to do it very, very briefly, is that there was no judgment because this was a PFS that required a voluntary dismissal, and it did not expressly say It did not track Mady. Mady was a proposal for settlement where it said, hey, this is what I'm paying you exclusive of fees and costs. We're carving out entitlement. We're carving out your right to seek attorney's fees. And none of that is expressly provided in this proposal for settlement. The second thing that we're missing is the prevailing party determination, because there was literally no showing made on that. And third is whether or not the court should exercise its discretion. In light of all this, we respectfully submit that this should be affirmed. With respect to the judgment inquiry, I think the court picked up that, exactly what it is, that we do not have a judgment. Rather, what we have is we have a proposal for settlement that says there's going to be a voluntary dismissal. And the case law on 501.2105 on FDUCT is clear. As Judge LaRose pointed out, you have to have a judgment. That is what the statute requires. The cases going back to the 80s have been consistent on this. It's two steps. Number one, you need a judgment. Then number two, you get into whether or not you have an entitlement. We don't have a judgment because the PFS is not crafted to require a judgment to be entered. And with respect to the trying to fit the Mady peg into the square opening of FDUCT, as it was pointed out during my colleague's presentation, Mass-Magnuson Warranty Act requires the plaintiff to finally prevail, not obtain a judgment before they can get fees. And if you finally prevail, then at that point, you can get fees put into a judgment. But it's different with the context of FDUCT. You got to have judgment first and then entitlement, and then you can get your fees into your judgment. No case, and this was conceded before the trial court, there's no case that has ever said that under 501.2105, accepting a proposal for settlement means that you get your fees. It just doesn't exist. And I appreciate the very broad language that Mr. Wallace was referring to in Mady, but there's a couple things that I think we really need to focus on. And the first is, this was a Magnuson-Moss Warranty Act. It has been cited literally by 5 opinions in the past 9 years. And it is very specific. The issue that was before the court was, and I quote, the critical issue, this is at page 1132, is whether the resolution of a claim filed pursuant to subsection D1 of the Mass-Magnuson Warranty Act by a monetary settlement pursuant to an offer of judgment statute is applicable to proceeding. There's the imprimatur of the court that would warrant the court to award fees. And that's just not what we have here. As Judge LaRose pointed out, the words do matter. We say judgment. Judgment is judgment. And when you go through the proposal for settlement, and I've actually highlighted a copy of it, I think it's important to note that what it does in the introductory paragraph, it says that this is a final and binding offer to resolve, and I'm quoting, all of Mr. Money's claims, monetary, non-monetary, damages, not damages, in the above captioned lawsuit in accordance with the terms set forth below. So this is a very broad proposal for settlement, but then the problem here is when you get to paragraph 4, it talks about how the proposal pertains to all claims for damages and monetary relief, which could be awarded in a final judgment, which is materially different from the proposal for settlement statute. And the kind of significant issues that we have is the proposal for settlement statute talks about how it should resolve all damages, otherwise awarded subject to subdivision F being the carve out for fees. But when you look at paragraph 4, there is no carve out for fees. And when you look at paragraph 5, which is the relevant condition of voluntarily dismissing the case with prejudice, it says, I'm going to dismiss everything that's covered in 4. Well, 4 doesn't get into attorney's fees. And then later on, you have this thing hanging out in paragraph 9, but even that's distinguishable from the proposal for settlement in Mady, where the amount says it's going to be exclusive of fees and costs. We acknowledge and appreciate that you might seek attorney's fees, and that stuff was addressed expressly in the Mady proposal for settlement. It's not addressed expressly here. If they were traveling under Mady, they should have followed the Mady proposal for settlement. With respect to the prevailing party piece of it, frankly, I just feel like there's a little bit of a revisionist history with what happened below. There was nothing, this was not set for an evidentiary hearing. There was nothing filed showing that, hey, we are the prevailing party here. That inquiry was not addressed before the trial court. And this is a situation where the appellant has the burden to make its record, to present the issues and to make the showings initially. It doesn't get to come up and get a reversal to get a second bite at the apple for something it made a tactical decision not to address because it made the argument that the proposal for settlement's acceptance in and of itself satisfied that inquiry. And with respect to the trial court's discretion, it's the same thing. We just didn't have those things. There was a tactical decision to not file anything on that, a tactical decision to not set this for an evidentiary hearing where those matters would be addressed. It's just not preserved. It can't be remanded to bring up something that was not preserved and to raise for the first time a new issue that they made a decision not to get into. And it's something, frankly, when you look at these factors under Humane Society and Riley, these are things that require something more than unsworn attorney statements. You need to have something that addresses the opposing party's ability to satisfy an award, whether an award of fees against the opposing party would deter others, the degree of the opposing party's culpability or bad faith, whether the defense is raised mainly were to frustrate or stall. And these are things that it just wasn't argued below. It wasn't until after my colleague, Mr. Picorni, consistent with the papers that were submitted, said, hey, these things haven't been addressed. At that point, appellant's trial counsel said, well, hey, I don't think we need it. But if you want me to, Judge, let's just kick this over to an evidentiary hearing. And respectfully, it's the plaintiff, the appellant's burden. They're the ones who should have done what they needed to do to present this appropriately to the trial court. It's not the trial court's fault that they failed to make those two showings that were required. Just going to touch very briefly that there's many distinctions between between the Mady proposal for settlement and the one that we have at issue here. And frankly, Your Honors, it's just confusing. I had a hard time with it because paragraph 4 says resolving all claims. Paragraph 5 says we're going to dismiss everything addressed in paragraph 4. And then you have paragraph 9 kind of hanging out there. And the amount doesn't say we're excluding out attorney's fees. So I think this was a situation where if we didn't accept it, it was going to be a darned if you do, darned if you don't situation. This was ambiguous enough that if we rejected it, let's say there was a nominal judgment for the plaintiff of $1,000 or $2,000, they could have come back and said, hey, look, the way that we said this, paragraphs 4 and 5 contemplated dismissing everything. So we think the attorney's fees we spent should have also been rolled in. And that's just not right. That's just not fair. And the post PFS communications are irrelevant. If it's ambiguous, you can't clarify with subsequent stuff. We were simply accepting a proposal for settlement. We took it as we found it. Neither the statutes, the rule, case law says you could supplement or amend or alter a proposal for settlement after the fact and have it bind on a party. And we've cited cases to the contrary from federal courts, which provide very good reason why that is simply not the way it should be. And I think the court highlighted and hit all the reasons why there are just the Magnuson-Moss Warranty Act and FDUPTA are just different. You need a judgment under the plain language of the statute under FDUPTA. You don't with Magnuson-Moss. Rather, you need to be the prevailing party, and then in a subsequently you can get fees looped in. And that is what Justice Kennedy's dissent in Mady really got into, which was joined by Justices Labarga and Polston. And it was focusing on the second piece of it, not the first piece of it, which is unique to FDUPTA. So and Mady's not controlling because it's not a FDUPTA case. So I'm confident that if this were to go out, if this were to move down the chain, the textual approach, which is the correct approach, which this panel has recognized, would be the one that would carry the day with respect to FDUPTA. And I acknowledge and appreciate Mr. Wallace's comment with regard to jurisdiction, but 768.79 sub 4 is very specific about what jurisdiction the court has after a proposal for settlement, and it's to enforce the settlement agreement. And if plaintiff appellant is now taking the position that paragraph 9 expressly carves out attorney's fees and costs, well, then the court doesn't have jurisdiction over that. You just have a dismissal, and it's over, and it's done, and we're done with it. And I think if there are no questions for me, I would just note a couple of things for the court to perhaps consider and focus in on. One is, why wasn't there why was the decision made to not set an evidentiary hearing? And why, if traveling under Mady, wasn't the form in Mady used, but rather this different one that I just feel has a lot of ambiguity in it, which could have resulted in, the Home Performance Alliance being darned if it does or darned if it doesn't. With that, I'll just conclude by saying that I think we all agree that it's 3 things that need to be shown. Only one of them was discussed previously. The other 2, there was no evidentiary hearing set to address it, and it was necessary. And so with that, we respectfully submit that even if the judgment prong were somehow met, the other 2 aren't, and it wasn't preserved. So we would respectfully submit that this simply needs to be affirmed.
Thank you, Mr. All right, Mr. Wallace, you have about, I'll give you the 4 minutes for rebuttal, sir. Okay.
Thank you. First off, on the so-called ambiguity of the proposal, I don't think that this proposal can be read to believe that it's ambiguous with regard to attorney's fees. The language of that paragraph, which is labeled in bold type attorney's fees, this proposal does not include attorney's fees or court costs, which plaintiff claims against defendant in this action. So I don't think that can be read to be ambiguous on the point of attorney's fees. With regard to the conduct of the hearing below, there was a discussion at the hearing about does this need to be reset for an evidentiary hearing? And of course that didn't happen because the court ruled against Mr. Money on the first step, that he needed a judgment and rejected the application of Mady. I think that if the trial court had agreed with Mr. Money that Mady applies and that the actual judgment is not necessary, what would have followed would have been an evidentiary hearing on those other factors. So I don't think there's any waiver stemming from that. Clearly, the trial court did not reach those issues as Home Performance conceded in its brief. And the result of that is that if this court reverses, that's what the trial court's going to do, is reach those issues on remand, which it would have done had it agreed on the Mady principle. On the concept of bilateral versus unilateral fee shifting statutes, I think Mady cites some cases that are bilateral. I don't think that's a distinction with a difference. On the issue of that you have to have that all the cases under 501 say you have to have a judgment. What you don't have is any 501 case under similar settlement circumstances that we have here since Mady that reaches that conclusion. The cases that the trial court relied upon are all pre-Mady. So we don't have a single case under 501 that had Mady under consideration when those cases were decided. With regard to what actually did the dissent argue in Mady, this is a line from the dissent in Mady. These statutes thus clearly, referring to Magnuson Moss, these statutes thus clearly contemplates that attorney's fees will be awarded only if some other relief is awarded by way of a judgment. No such relief was awarded to Mady. So the very argument that the statute under consideration, in that case Magnuson Moss, said judgment, the very argument in the dissent was statute says judgment, it means judgment, got to have a judgment. That argument was rejected, and it was rejected based on the general principles that I cited to before, which are general enough to apply to our case. Our proposal is not radically different from Mady. Our proposal carved out attorney's fees. Our proposal had a dismissal. The proposal in Mady had a dismissal. Our dismissal carved out attorney's fees.
Mr. Wallace, you need to wrap it up.
Okay. Your Honor, in conclusion, what we're asking for is a remand so that the court can consider the discretionary factors and apply those factors to determine whether Mr. Money is entitled to attorney's fees with the Mady app applied to substitute for the actual judgment.
Very good. Thank you, gentlemen. Thank you.
Thank you, Your Honors.
Thank
you,
you,
David.
Thank you.